Persons and family relations. When law takes effect, doctrine. When the laws become effective. General Rule 15 days after completion of publication in official gazette or a newspaper of general circulation. Article 2. Exception to the general rule, the law can provide for its own date of effectivity. An immediate effectivity clause does not preclude the requirement of publication. Mandatory publication. Publication is mandatory and must be in full, otherwise, it is not deemed published at all, since its purpose is to inform the public of its contents. After the accomplishment of this requirement, the people are deemed to have conclusively been notified of the law, even if actually the people or some of the same have not read them. Effectivity of laws. General Rule. When a statute does not explicitly provide for its effectivity, it shall have effect only after the expiration of the 15-day period following the completion of its publication either in the official gazette or in a newspaper of general circulation in the Philippines. Covered by this rule are presidential decrees and executive orders, administrative rules and regulations, charter of a city. However, interpretative regulations and those merely internal in nature, that is, regulating only the personnel of the administrative agency and not the public, need not be published. Exception to the general rule, if the law provides for a different period shorter or longer than the 15 period, then such short or longer period, as the case may be, will prevail. If the law provides that it shall take effect immediately, it means that it shall take immediately after publication, with the 15-day period being dispensed with. The clause, unless it is otherwise provided, solely refers to the 15-day period and not to the requirement of publication. Publication is an indispensable requisite, the absence of which will not render the law effective. It is not correct to say that under the disputed clause, publication may be dispensed with altogether. The reason is that such omission would offend due process insofar as it would deny the public of the laws that are supposed to govern it. Tanida v. Tuvera. It would be the height of injustice to punish or otherwise burden a citizen for the transgression of a law of which he had no notice whatsoever, not even a constructive one. Compliance with the law. Ignorance of the law excuses no one from compliance therewith. Ignorant leges non excusat. Article 3. Article 3 applies only to mandatory and prohibitory law. When a law is passed by Congress, duly approved by the President, properly published and consequently becomes effective pursuant to its effectivity clause, the public is always put on constructive notice of the law's existence and effectivity. Retroactivity of laws. General Rule, laws are not retroactive. Article 4. Non-retroactivity of laws. Gr. Statutes are to be construed as having only prospective operation, unless the purpose and intention of the legislature to give them retrospective effect is expressly declared or is necessarily implied from the language used, and that, in case of doubt, the same must be resolved against the retrospective effect. Exception to the general rule, instances which may be given retroactive effect. 1. Penal laws when favorable to the accused who is not a habitual delinquent or recidivist. 2. Interpretative statutes. When the law is curative or remedial, adding to the means of enforcing existing obligations. When the law is procedural, those which have accrued or pending and future actions. Thus a law prescribing the form of pleadings will apply to all pleadings filed after its enactment, although the action is begun before that time. 3. When the law itself expressly provides for laws creating new substantive rights. Mandatory or prohibitory laws. Article 5. General Rule acts executed against the provisions of mandatory or prohibitory laws shall be void. Exception if the law expressly provides for the validity of acts committed in violation of a mandatory or prohibitory provision of a statute. Prohibitory laws are those which contain positive prohibitions and are couched in the negative terms importing that the act required shall not be done otherwise designated. Waiver of rights. A right, a legally enforceable claim of one person against another, that the other shall do a given act, or shall not do a given act. Waiver is the intentional relinquishment of a known right. Waivers are not presumed, but must be clearly and convincingly shown, either by express stipulation or acts admitting no other reasonable explanation, and it must be exercised by a duly capacitated person actually possessing the right to make a waiver. Where one lacks knowledge of a right, there is no basis upon which waiver of it can rest. Ignorance of material fact negates waiver, and waiver cannot be established by a consent given under a mistake or misapprehension of fact. Kinds of rights. Natural rights, those which grow out of the nature of man and depend upon personality. Example, right to life, liberty, privacy, and good reputation. Political rights consist in the power to participate, directly or indirectly, in the establishment or administration of government. Example, right of suffrage, right to hold public office, right of petition. Civil rights, those that pertain to a person by virtue of his citizenship in a state or community. Example, property rights, marriage, equal protection of laws, freedom of contract, trial by jury. Real rights, enforceable against the whole world. Personal rights, enforceable against a particular individual. General rule, rights may be waived. Article 6. Requisites of a valid waiver, as held in the case of Herrera versus Borromeo. 1. Existence of a right. 2. Knowledge of the existence of such right, and 3. An intention to relinquish the right. Exceptions, when waiver is 1. Contrary to law, public order, public policy, morals, good customs, e.g. waiver of future inheritance, political rights, future support. Signing by a disabled employee of a satisfaction receipt does not constitute a waiver. The law does not consider as valid any agreement to receive less compensation than the worker is entitled to recover under the law. A private agreement between a husband and wife providing that they consent or allow the commission of adultery or concubinage is a void agreement or a void waiver of rights, as the same is contrary to public interest and morals. 2. Prejudicial to a third person with a right recognized by law. 3. Natural rights, such as right to life. 4. A right not yet in actual existence, right in esse, example future inheritance. Case laws. Co versus Ariano University. Scholars waiver to transfer to another school. This was not considered as a valid waiver because it was contrary to morals and public policy, because scholarships are not supposed to be granted to students simply as business dealings somehow to attract and maintain brilliant students. Leal versus IAC. Sale of property where it was provided that the buyer cannot sell the land except back to the seller or his heirs and of the same price it was sold to him. It is considered as undue and unwarranted/illegal restriction and perpetual restriction on the right to private ownership. Article 11. Customs, which are contrary to law, public order or public policy shall not be countenanced. Article 12. A custom must be proved as a fact, according to the rules of evidence. Custom has been defined as a rule of conduct formed by repetition of acts, uniformly observed, practiced, as a social rule, legally binding and obligatory. A local custom as a source of right cannot be considered by a court of justice unless such custom is properly established by a competent evidence like any other fact. Custom, even if proven, cannot prevail over a statutory rule or even a legal enunciated by the Supreme Court. General rule, customs must be proved as a fact. Exception, a court may take judicial notice of a custom if there is already a decision rendered by the same court recognizing the custom. Article 13. When the laws speak of years, months, days or nights, it shall be understood that years are of 365 days each, months, of 30 days, days, of 24 hours, and nights from sunset to sunrise. If months are designated by their name, they shall be computed by the number of days which they respectively have. In the case of Garvida versus Sales, the phrase, not more than 21 years of age, means not over 21 years. It means 21,365 day cycles. It does not mean 21 years and 1 or some days. Not more than 21 years old is not equivalent to less than 22 years old. Years 365 days. When the law speaks of years, it is always 365 days regardless of the fact of leap year. Territoriality Principle. Article 14. Penal laws and those of public security and safety shall be obligatory upon all who live or sojourn in the Philippine territory, subject to the principles of public international law and to treaty stipulations. The liability for any violation of the said laws will even attach regardless of whether a foreigner is merely sojourning in Philippine territory. Exception. Foreigners may be immune from suit in certain cases. Where the PH government has waived its criminal jurisdiction over them on the basis of the principles of public international law and treaty stipulations. Example, Vienna Convention on Diplomatic Relations. Person of the diplomatic agent shall be inviolable and he shall not be liable to any form of arrest or detention. Lex Nationale. Article 15. Laws relating to family rights and duties, or to the status, condition and legal capacity of persons are binding upon citizens of the Philippines, even though living abroad. Nationality Rule. Regardless of where a citizen of the Philippines might be, he or she will be governed by Philippines law with respect to his or her family rights and duties, or to his or her condition and legal capacity. Hence, if two Filipino minors married in other country and in that country, it is legal that minors can marry, their marriage is still void ab initio because status is determined by Philippine law. No absolute divorce, but SC has recognized absolute divorce. Article 26 Paragraph 2 Family Code. Lex Recite. Article 16. Real property as well as personal property is subject to the law of the country where it is stipulated. However, intestate and testamentary successions, both with respect to the order of succession and to the amount of successional rights and to the intrinsic validity of testamentary provisions, shall be regulated by the national law of the person whose succession is under consideration, whatever may be the nature of the property and regardless of the country wherein said property may be found. General Rule, Real property, where it is situated. Exception, national law of the deceased on the 4 items. Regardless where his property may be found with these 4 items. A. The order of succession. B. The amount of successional rights. C. The intrinsic validity of the provisions of the will, and D. The capacity to succeed. Lex Loci Celebrationis. Article 17. The forms and solemnities of contracts, wills, and other public instruments shall be governed by the laws of the country in which they are executed. When the acts referred to are executed before the diplomatic or consular officials of the Republic of the Philippines in a foreign country, the solemnities established by Philippine laws shall be observed in their execution. Prohibitive laws concerning persons, their acts or property, and those which have for their object public order, public policy, and good customs shall not be rendered ineffective by laws or judgments promulgated, or by determinations or conventions agreed upon in a foreign country. Extrinsic validity. Laws of the country where they are executed. Acts before diplomatic and consular officials. Diplomatic and consular officials representatives of the state. Hence, any act or contract made in a foreign country before diplomatic and consular officials must conform to the solemnities under Philippine law. Marriages between Filipinos solemnized by a consular official abroad must be made following Philippine laws. Thus, the issuance of the marriage license and the duties of the local civil registrar with regard to the celebration of the marriage shall be performed by a consul general, consul or vice-consul abroad. Doctrine of Renvoa. The Renvoa doctrine, referring back, is a legal doctrine which applies when a court is faced with a conflict of law and must consider the law of another state, referred to as private international law rules. This can apply when considering foreign issues arising in succession planning and in administering estates. Renvoa takes place when the conflict's rule of the forum makes a reference to a foreign law, but the foreign law is found to contain a conflict rule that returns or refers the matter back to the law of the forum, remission. Doctrine of processual presumption. Under the doctrine of processual presumption, if the foreign law involved is not properly pleaded and proved, our courts will presume that the foreign law is the same as our local or domestic or internal law. However, when the foreign law, judgment or contract is contrary to a sound and established public policy of the forum, the said foreign law, judgment or order shall not be applied. Transmission theory, if the foreign law refers it to a third country, the said country's law shall govern. Human relations in relation to persons. Article 19. Every person must, in the exercise of his rights and in the performance of his duties, act with justice, give everyone his due, and observe honesty and good faith. Principle of abuse of right. When a right is exercised in a manner which does not conform with the norms enshrined in Article 19 and results in damage to another, a legal wrong is thereby committed for which the wrongdoer must be held responsible. Elements of abuse of right. 1. There is a legal right or duty. 2. Which is exercised in bad faith. 3. For the sole intent of prejudicing or injuring another. Human relations in relation to persons. Malice or bad faith is the core of said provision. Good faith is presumed and he who alleges bad faith has the duty to prove the same. It consists of intention to abstain from taking an unconscionable and unscrupulous advantage of another. Article 20. Every person who, contrary to law, willfully or negligently causes damage to another, shall indemnify the latter for the same. Article 20. Even not bad faith. As long as there is damage, then liable for negligence. Thus, anyone who, whether willfully or negligently, in the exercise of his legal right or duty, causes damage to another, shall indemnify his or her victim for injuries suffered thereby. Article 21. Any person who willfully causes loss or injury to another in manner that is contrary to morals, good customs or public policy shall compensate the latter for the damage. Article 21. Contra bonus mores / contrary to morals. Victim of moral wrongs helpless. Elements. Article 21. 1. There is an act which is legal. 2. But which is contrary to morals, good customs, public order, or public policy, and 3. It is done with intent to injure. In Article 19 and Amp. 21, the act must be intentional, while in Article 20, it must be willfully or negligently. Breach of promise to marry. General rule: a mere promise to marry is not actionable per se / sufficient basis for an award for damages. Exceptions. 1. If there is fraud or deceit. 2. If expenses are actually incurred. 3. Moral seduction. For when a woman was forcibly abducted and raped and thereafter promised marriage in order to escape criminal responsibility only to renege on such promise. Case laws. Wasmer v. Valles, postponed mother opposes it. Mere breach of promise to marry is not an actionable wrong. But to formally set a wedding and go through all the preparation, application for marriage license, distribution of wedding invitations, etc., and publicity, only to walk out of it when the matrimony is about to be solemnized, is quite different. This is palpably and unjustifiably contrary to good customs for which Valles must be held answerable in damages in accordance with Article 21. Not a simple breach of promise to marry. Significantly, while a breach of promise to marry is not actionable, it has been held that to formally set a wedding and go through and spend for all the wedding preparations and publicity, only to walk out of it when matrimony was about to be solemnized, is a different matter. This is palpably and unjustifiably contrary to good customs, which defendant must be answerable to damages. Where a man's promise to marry is the proximate cause of giving herself to him, there is moral seduction. Justifies the award of damages. Baksh vs. CA, Iranian student who is already married. Such could justify the award of damages pursuant to Article 21 not because of such promise to marry but because of the fraud and deceit behind it and the willful injury to her honor and reputation which followed thereafter. In the same vein, it has been held that for a married man to force a woman not his wife to yield to his lust, constitutes a clear violation of the rights of his victim, which entitled her to compensation under Article 21. A promise to marry, which is the proximate cause of the acceptance of his love and giving of herself unto him in a sexual congress, justify the award of damages pursuant to Article 21, not because of such breach of promise to marry, but because of the fraud and deceit behind it and the willful injury to her honor and reputation which followed thereafter. Unjust enrichment. Article 22. Every person who through an act of performance by another, or any other means, acquires or comes into possession of something at the expense of the latter without just or legal ground, shall return the same to him. Article 23. Even when an act or event causing damage to another's property was not due to the fault or negligence of the defendant, the latter shall be liable for indemnity if through the act or event he was benefited. Unjust enrichment. No person can claim what is not validly and legally his or hers. Hence, he or she should not unduly profit on something which does not meritoriously belong to him or her. It is a well-known principle of law that no one should be permitted to enrich himself to the damage of another. A judgment creditor would not be permitted to retain the purchase price of land sold as the property of the judgment debtor after it has been made to appear that the judgment debtor had no title thereto. There is unjust enrichment when a person unjustly retains a benefit to the loss of another, or when a person retains money or property of another against the fundamental case doctrine. The principle of unjust enrichment cannot be invoked if an alien purchases a land in the PH and agrees to have it titled in the name of a Filipina. He knowingly violates the Constitution. Being a party to an illegal contract cannot come to court and have his illegal objective carried out. One who loses money or property by engaging in a contract may not take an action for his losses. Article 26. Every person shall respect the dignity, personality, privacy, and peace of mind of his neighbors and other persons. The following and similar acts, though they may not constitute a criminal offense, shall produce a cause of action for damages, prevention, and other relief. 1. Prying into the privacy of another's residence. 2. Meddling with or disturbing the private life or family relations of another. 3. Intriguing to cause another to be alienated from his friends. 4. Vexing or humiliating another on account of his religious beliefs, lowly station in life, place of birth, physical defect, or other personal condition. Note: enumeration not exclusive, only given by example. Art 27. Any person suffering material or moral loss because a public servant or employee refuses or neglects, without just cause, to perform his official duty may file an action for damages and other relief against the latter, without prejudice to any disciplinary administrative action that may be taken. A public official may be made to pay damages for performing a perfectly legal act, albeit with bad faith or in violation of the abuse of right doctrine embodied in the preliminary articles of the Civil Code concerning human relations. Capacity to act. Article 37. Juridical capacity, which is the fitness to be the subject of legal relations, is inherent in every natural person and is lost only through death. Capacity to act, which is the power to do acts with legal effect, is acquired and may be lost. Juridical capacity and capacity to act differentiated. Juridical capacity means fitness to be the subject of legal relations. It is inherent and lost only through death and can exist even without capacity to act. On the other hand, capacity to act means power to do acts with legal effect. It is merely acquired and lost through death and other causes. It always exists with juridical capacity. Restrictions on capacity to act. Article 38. Minority, insanity or imbecility, the state of being a deaf, mute, prodigality, and civil interdiction are mere restrictions on capacity to act, and do not exempt the incapacitated person from certain obligations, as when the latter arise from his acts or from property relations, such as easements. 1. Minority does not exempt the minor from certain obligations. If he does an act without the consent of his parents or guardian, the contract is not void but is merely voidable, that is valid until annulled. 2. Insanity, imbecility. 3. State of being deaf-mute. 4. Prodigality, state of squandering money. 5. Civil interdiction, merely restricts and do not extinguish capacity to act. Accessory penalty. Birth and death of natural persons. Birth. Article 40. Birth determines personality, but the conceived child shall be considered born for all purposes that are favorable to it, provided it be born later with the conditions specified in the following article. General rule: birth determines personality. Exception: presumptive personality. The civil personality of the child shall commence from the time of its conception, for all purposes favorable to him, subject to the requirements of Article 41. Example: father instituted his unborn child as an heir. He died while daughter is 6 months in the womb of the wife. Wife prematurely gave birth 6 months, and right after birth, the baby died, did not acquire civil personality because it did not comply with the requirements under Article 41. Hence, the child did not acquire right to the inheritance. If baby was born 8 months then died after few minutes, the baby acquires the right to inheritance. Article 41. For civil purposes, the fetus is considered born if it is alive at the time it is completely delivered from the mother's womb. However, if the fetus had an intrauterine life of less than 7 months, it is not deemed born if it dies within 24 hours after its complete delivery from the maternal womb. General rule: fetus is considered born if it is alive at the time it is completely delivered from the mother's womb. From the time of the cutting of the umbilical cord. Exception: the fetus had an intrauterine life of less than 7 months. It is not deemed born if it dies within 24 hours after its complete delivery from the maternal womb. Case: Jalas vs. C.A. The concept of provisional personality cannot be invoked to obtain damages for and in behalf of an aborted child. Unborn fetus has no personality, hence, no damages on behalf of the unborn child. Death. Article 42. Civil personality is extinguished by death. The effect of death upon the rights and obligations of the deceased is determined by law, by contract, and by will. Case: by reason of the very nature of the relationship between principal and agent, agency is extinguished by the death of the principal or of the agent. It follows a fortiori that any act of an agent after the death of his principal is void ab initio unless the same falls under the exceptions provided for in Articles 1930 and 1931. Death extinguishes criminal liability. Civil liability, however, generally subsists. Only civil liability ex delicto is extinguished. Presumption of survivorship. Article 43. If there is a doubt, as between two or more persons who are called to succeed each other, as to which of them died first, whoever alleges the death of one prior to the other, shall prove the same. In the absence of proof, it is presumed that they died at the same time and there shall be no transmission of rights from one to the other. Presumption of survivorship. If there is a doubt, as between two or more persons who are called to succeed each other, as to which of them died first. A. Whoever alleges the death of one prior to the other, shall prove the same. B. In the absence of proof, it is presumed that they died at the same time and there shall be no transmission of rights from one to the other. In other situations, where the persons are called to succeed each other, Rule 131, Section 3 JJ. 1. If both were under 15, the older is deemed to have survived. 2. If both were above 60, the younger is deemed to have survived. 3. If one is 15 and the other is above 60, the former is deemed to have survived. 4. If both be over 15 and under 60, and the sex be different, the male is deemed to have survived. If the same be the same, the older. 5. If one be under 15 or over 60, and the other between those ages, the latter is deemed to have survived. Surnames. Legitimate and legitimated children. Article 364. Legitimate and legitimated children shall principally use the surname of the father. Indeed, the provision states that legitimate children shall principally use the surname of the father, but principally does not mean exclusively. This gives ample room to incorporate into Article 364 the state policy of ensuring the fundamental equality of women and men before the law, and no discernible reason to ignore it. Adopted children. Article 365. An adopted child shall bear the surname of the adopter. Illegitimate children. Art. 368. Illegitimate children referred to in Article 287 shall bear the surname of the mother. Note, Republic Act, if recognized by the father, they may use father's name as surname. Case. Respondent is the father of petitioner, Andre. Respondent filed a petition for recognition of his illegitimate children with prayer for custody and change of name. RTC allowed. CA modified decision and awarded custody to the mother. Supreme Court held that the children cannot be compelled to use the surname of the father. General Rule, Mother's surname. Illegitimate children may use the surname of the father if filiation is recognized by father either by record of birth or private handwritten. Here, RA merely gives the illegitimate child the right to use the name of their father. Discretion is upon the illegitimate child. Married women. Article 370. A married woman may use 1. Her maiden first name and surname and add her husband's surname, or 2. Her maiden first name and her husband's surname, or 3. Her husband's full name, but prefixing a word indicating that she is his wife, such as Mrs. Case. A married woman has an option, but not a duty, to use the surname of the husband in any of the ways provided by Article 370 of the Civil Code. However, once a married woman opted to adopt her husband's surname in her passport, she may not revert to the use of her maiden name, except in the cases enumerated in Section 5(d) of RA 8239. These instances are 1. Death of husband. 2. Divorce. 3. Annulment, or 4. Nullity of marriage. Since petitioner's marriage to her husband subsists, she may not resume her maiden name in the replacement passport. Otherwise stated, a married woman's reversion to the use of her maiden name must be based only on the severance of the marriage. Note, not included in the exceptions is legal separation. Legal separation do not result to severance of marital ties. Change of name. Art. 376. No person can change his name or surname without judicial authority. In Republic v. Hernandez, we have recognized inter alia the following as sufficient grounds to warrant a change of name. A. When the name is ridiculous, dishonorable or extremely difficult to write or pronounce. B. When the change is a legal consequence of legitimation or adoption. C. When the change will avoid confusion. D. When one has continuously used and been known since childhood by a Filipino name and was unaware of alien parentage. E. When the change is based on a sincere desire to adopt a Filipino name to erase signs of former alienage, all in good faith and without prejudice to anybody, and F. When the surname causes embarrassment and there is no showing that the desired change of name was for a fraudulent purpose, or that the change of name would prejudice public interest. Rules governing persons who are absent. Provisional measures in case of absence, temporary absence. When a person disappears from his domicile, his whereabout being unknown, and without leaving an administrator of his properties. Art. 381. When a person disappears from his domicile, his whereabouts being unknown, and without leaving an agent to administer his property, the judge, at the instance of an interested party, a relative, or a friend, may appoint a person to represent him in all that may be necessary. Appointment of an administrator of his property. His wife is preferred to administrator. Art. 382. The appointment referred to in the preceding article having been made, the judge shall take the necessary measures to safeguard the rights and interests of the absentee and shall specify the powers, obligations and remuneration of his representative, regulating them, according to the circumstances, by the rules concerning guardians. Declaration of absence. Declaration of absence by the court if the disappearance is 2 years, and if he left behind an administrator of his properties, he can be declared an absentee after 5 years. Article 384. 2 years having elapsed without any news about the absentee or since the receipt of the last news, and 5 years in case the absentee has left a person in charge of the administration of his property, his absence may be declared. Who can ask for declaration of absence? Article 385. The following may ask for the declaration of absence. 1. The spouse present. 2. The heirs instituted in a will, who may present an authentic copy of the same. 3. The relatives who may succeed by the law of intestacy. 4. Those who may have over the property of the absentee some right subordinated to the condition of his death. Art. 386. The judicial declaration of absence shall not take effect until 6 months after its publication in a newspaper of general circulation. Administration of the property of the absentee. Art. 388. The wife who is appointed as an administratrix of the husband's property cannot alienate or encumber the husband's property, or that of the conjugal partnership, without judicial authority. Art. 389. The administration shall cease in any of the cases. 1. When the absentee appears personally or by means of an agent. 2. When the death of the absentee is proved and his testate or intestate heirs appear. 3. When a third person appears, showing by a proper document that he has acquired the absentee's property by purchase or other title. Presumption of death. Ordinary disappearance. Art. 390. After an absence of 7 years, it being unknown whether or not the absentee still lives, he shall be presumed dead for all purposes, except for those of succession. The presumption of death under Art. 390 and 391 of the Civil Code arises by operation of law, without need of court declaration, once the factual conditions mentioned in the said articles are established. Opening up of estate at 10 years. The absentee shall not be presumed dead for the purpose of opening his succession till after an absence of 10 years. If he disappeared after the age of 75 years, an absence of 5 years shall be sufficient in order that his succession may be opened. Extraordinary disappearance, 4 years. Art. 391. The following shall be presumed dead for all purposes, including the division of the estate among the heirs. 1. A person on board a vessel lost during a sea voyage, or an aeroplane which is missing, who has not been heard of for 4 years since the loss of the vessel or aeroplane. 2. A person in the armed forces who has taken part in war, and has been missing for 4 years. 3. A person who has been in danger of death under other circumstances and his existence has not been known for years.